Welcome to today's webinar hosted by DISA Global Solutions. I'm Jessica Polk of the Current Consulting Group, and I'll be conducting today's presentation, Policy, Training, and Compliance, the Building Blocks of Your Substance Abuse Program. And we'd like to just remind you, if you have any technical problems, please use the chat section. Today's presentation is going to be very informative, and as such, we are going to exclude a live Q&A, but we do prioritize your questions and want you to submit them. So there is a questions section where you can type in any questions that you have for today's presenter or questions about today's content. Please feel free to use that question section, and we will have a DISA team member respond to you offline. So just know that that question section is for any questions in today's presentation, and those questions will be answered offline. We'd like to thank DISA Global Solutions for hosting today's webinar. DISA Global Solutions is an industry-leading employee screening company since 1982. And with us today is Nina French from the Current Consulting Group. She's the managing partner for the Current Consulting Group, and she began her career in the screening industry in 1992 and has experience in all aspects of drug-free workplace operations, product development, and sales strategy. She's nationally recognized as an expert in substance abuse testing and is widely published and has been featured in U.S. News, World Report, NAPBS News, EHS, OHS, SHRM, DISA, SAPA, NAPBS, and speaks at over 40 events annually. Also with us today is Kalinda Howard from DISA Global Solutions. She serves as their Governance and Risk Director. Kalinda is a licensed attorney and seasoned compliance professional with 20 years of experience managing legal matters, ethic investigations, and compliance programs ranging from bankruptcy, mortgage-backed securities, real estate, predatory lending, human resources, retail operations, and now employment screening. And Kalinda also leads she leads DISA's drug testing compliance team, which focuses on legislative regulatory standards and drug and alcohol testing. And so to start us off, I'm going to go ahead and turn things over to Kalinda.
As part of DISA's ongoing commitment to compliance, we have Nina French of the Current Consulting Group here to update you on the rapidly changing legal landscape and its impact on policy, training, and audit support. Fun fact, so far in 2019, there have been over 450 bills introduced that impact workplace drug testing, and as I hope each of you is aware, these changes will impact your programs and policies. Today's session will provide a broad overview of those changes. We'll review the training requirements and give a brief update on audit. Thank you, Nina.
Thanks, Kalinda, and thanks for everybody who's attending today. We are not going to go the full hour, hopefully. I tend to get into this and sometimes lose track of time, but I'll try and keep this shorter than an hour so that everybody can get a break before their next meeting. And what I do want to cover for you, and thank you for DISA for having us, and by the way, nothing's more intimidating than a non-lawyer presenting with a lawyer when we're talking about laws. So I always put that as the caveat. I'm not a lawyer, Kalinda is. But the reason that I present this so often and have this material sort of in my practice is that I talk to non-lawyers mostly, right? And so it's difficult to understand what these legislative updates and changes are in sort of the run-of-the-mill use in the workplace. And so I try and make this information available to you so that you can always access the legalese, I guess, of each of these laws. But today we're going to go through them to give you the general overview and hopefully to give you some insight into how things are changing, what's changing, and how it's going to impact your actual workplace, whether you're in safety or HR, whatever your role is at your workplace. DISA's industry leader in drug testing, but also in compliance. What is always concerning is, no matter how good the systems are, no matter how good the people are and the process is, are you as clients or prospects or employers really taking to heart what is your responsibility and availing yourself of all of the things that have, that DISA has available to you. So today we're going to go through the legislative updates, and like I said, not in tremendous legal detail, but hopefully to give you guys a sense of what's changing and how it'll impact you. And then we're going to talk about those required changes, what it means specifically to you. And then let's talk a little bit about employee education and audit support as well, because these are really the compliance areas that DISA has a significant amount of resources for employers in. And so again, really want to try and avail yourself upon those resources within the DISA window. So trends in legislation, Kalinda mentioned, so far in 2019, there are over 450 bills that are proposed. Some have passed, some have failed, some are still pending. And all of those different bills relate to and will impact workplace drug testing and the workplace and substance abuse, right? Some of them, like these very first one, the State Controlled Substances Act, the definition and the acts themselves have a lot less importance than understanding it from a policy standpoint. So when you look at the CSA drug definitions, there are 12 states and Congress who have bills that are under review, and they have to do with removing hemp from the definition of marijuana and then removing marijuana as a Schedule I substance. Now, we don't know if they'll pass or not, right? We don't know what the impact of those will be. What I do know is that one of the questions that we field now almost more than any one is, how as an employer do we address CBD in our drug testing policy? The fact of the matter is, right now in the United States, CBD is unregulated, right? The FDA hasn't had clinical testing. The FDA is being much more active than in past years, cracking down on false claims or unsubstantiated claims by manufacturers, employers, distributors, about what CBD can do. Because the fact of the matter is, most times we don't really know what CBD can do. It has not gone through that process of clinical trials. So what we do know is that in almost every state where CBD is allowed or legal, there's a portion of that product that has THC in it, right? The THC makes you positive on a drug test. Now, will it in the low amounts of CBD? We don't know. Will it in oil versus in a product? We don't know. That's really the point. The point is it's very unregulated. It's very untested. We've seen cases where people have alleged that their only use was a CBD product, but they've tested positive for THC. So as an employer, again, all of this is saying, hey, talk to DISA about your policy and make sure you've got it right, and they can help you with the language. But as an employer, the answer is, we don't know how you got it in your system. But what we do know is, without a legitimate medical explanation or in adherence to our policy, it does not matter. The MRO cannot prove one way or the other, with a few exceptions, right? If they have a prescription, they can assume that prescription is how you got the THC. Now, keep in mind, there's no prescriptions for marijuana right now in the United States, with the exception of about 3 FDA-approved drugs. So when you're talking about medicinal marijuana is actually a card or a card holder, but it's not really a prescription. So again, when you're looking at your policy and the wording of your policy, you got to be super careful about how all of these things are going to apply in your policy and in your workplace. But when it comes to CBD use, you don't really even have to, per se, mention it in your policy, but, it is recommended that you have the tool in your toolkit when discussing this with employees. And the answer is, the only way you can be sure that a CBD product in this unregulated environment is going to not cause a positive for THC is if you do not use any CBD products. There's just no way of knowing right now if any specific product will make you test positive, no matter what the label says, no matter what the state says. It's so unregulated right now, there's really no way to know. So when you're thinking about this Controlled Substances Act, hemp and CBD, that's really what I want you to take away. When you look at the next topic, which are the state drug testing law updates, there's 22 states in Congress, and they're across the board. Again, this is sort of the legislation of marijuana in the United States right now is really a shotgun approach, right? They're throwing a whole bunch of different things out there without regard to which ones are hitting and where they're hitting and how they're hitting. And so the topics are extraordinarily different. So some of these are amending voluntary laws that are already in place. Others, and we'll talk about one, affects the MRO procedures. Some are the amending of the mandatory guidelines for federal workplace drug testing, but there are lots of them out there, and you've got to keep your eye on them. Drug testing adulterant laws, another thing we're seeing, it's a rising trend, and the laws are getting more strict. They're saying that they're trying to prohibit masking products, synthetic urines, the use of other bodily fluids, and those are in 6 states. So it's not just marijuana that's being legislated. It's really across the board. We're actually going to see some additional drugs that are now legal in certain states that I'm sure if you're not following this trend closely, you probably are unaware of. This next group of laws are some that I think are very important for you. Right? We're seeing in 14 states in Congress where there are laws with employee protections in the marijuana laws. And that's a broad term. And it ranges from like general protections to very explicit protections that limit your right as an employer to either test or to test and discipline. And we're going to go over a couple of those examples as well. But again, super important. I say this with a fair amount of confidence that if you have not had your policy reviewed or updated in the past 18 months, it is likely out of date. So we should be, hearing from DISA that they're getting hundreds of clients coming every year and saying, I want this updated or changed. And the interesting piece is we work with many different organizations. DISA is a large organization. We rarely see that. And if you're DOT regulated, you've got updates. If you're non-DOT regulated, you've likely got updates as well. And the policy is your responsibility as an employer. Now, if you fall into certain consortiums, of course you're going to get those updates from DISA. But it's really important for you to know that that obligation's yours to hold. And you've got to really be up on these different laws. And you've got to really have it sort of on the list of things that you check as you go into each new year. The crazy thing is now, where we used to say a year or two, you were okay. Now these are changing so rapidly that it might be something that you want to look into every 6 months or so, depending on how large you are and where your footprint of employees are. So the employee protections sort of restrict what you can do and how you can do it as an employer. There are 8 states that have employer protections in marijuana laws. So the idea there is that it's protections for you and that they pair with the employee protections. And again, when I get to the examples, that's going to make that a little bit more clear for you what they mean. But in general, what they do is allow you to still have a drug-free workplace. But we'll see where some of these new ones are creeping in that are making that a little bit more difficult for you to continue in the same way you've been doing it. Hemp and legalization, we talked a bit about that already. So we know that hemp legalization and production is in response to the 2018 Farm Bill. And they're sort of separating out hemp. Doesn't get you high. Simplest way to put it. I'm also not a doctor, so I like to just make it plain English, right? CBD is not psychoactive. Doesn't make you high. THC makes you high, right? CBD is thought to have a tremendous amount of medicinal value, but like we said, not regulated, hasn't gone through clinical trials, and so its benefits are largely unknown or unproven right now. Same with THC. Lots of claims, but we don't know that they're proven yet. And so it's going to be interesting as we see this over the next 20 years. And that's what that hemp law is about, okay? Trying to separate those two. Because a lot of people don't understand what is the difference. What's the difference between CBD and you know, sort of marijuana is this all-encompassing term. So that's why we're starting to now get smarter and break that out a little bit. Now, when we talk about some of the other laws, medical marijuana legalization is obviously important. And there are now, if you look at these two first bullets, right, medical marijuana legalization, medical marijuana qualifying conditions. Now, keep in mind, medical marijuana first started, it was legalized in 1996 in California. And then it wasn't until, I believe, it wasn't until 2012 that we saw any recreational marijuana, and that was in Washington and Colorado, right? So medical marijuana laws have been around for a long time, and now we're seeing laws that are modifying those existing laws or proposing new ones. So some of them are narrow bills that provide more limited access in those states where it's legal. Others are looking at adding opioid abuse or autism spectrum or other wider access for employees. Now, I know I live in Pennsylvania. Pennsylvania had originally for medical marijuana 7 qualifying conditions, and they are looking to expand that. So you've got to see what they are and know what they are in your state. And then recreational marijuana legalization is exploding, of course, right? So right now we have 34 states plus the District of Columbia that have medical marijuana legalized in some way, shape, or form. And again, keep in mind, very different across states. And we have 11 states, I believe, as of today, and DC, where marijuana is available recreationally. And again, they vary dramatically. So if you go to California, for instance, you can sit in your hotel room and you can have marijuana delivered to you in many different forms, right? Pre-rolled joints, you can have the flower itself, you can have edibles delivered, you can have oils, all sorts of things delivered to your hotel room with a valid license. It can usually be there in about an hour or under. It can be all done on an app. When you go to DC, right, in contrast, even though DC's laws, and again, I'm paraphrasing here, people, but like in DC's law, they're kind of controlled by Congress, so it's even more convoluted than others. So for DC, if you're on M Street, right, you can go to a distributor or dispensary, but I don't think they're allowed to call it a dispensary technically. And even though it's legal, you can't sell it, you can't purchase it, you can't bring it across state lines. So what you do there is, you can't do it on your app from your hotel room, but if you walk in, you can purchase cookies. And then they'll throw in the marijuana you want, because you can't technically actually buy the marijuana, even though it's legal. So you got to buy the cookies. So you'd say, I want one cookie. The cookie doesn't have marijuana in it. The cookie's just a plain old cookie. But you get the marijuana as a free gift. And that's the way they get around it. And so again, this is like how the impact of these laws for you as an employer make it very, very difficult, and will ultimately make it very, very costly as you try and navigate what makes sense in these different states and with these different laws. And there are just so many of them coming. So again, 21 states in Congress are now have bills that are looking at recreationally legal marijuana, and there's complications with that, and we're going to see some more of that as we go through some of these specific states and what they've got available for us. So let's look at Illinois. Age 21 and older, and it implements tax regulatory systems, blah, 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 right? Goes into effect January 1. This one's a done deal. When you look at how it addresses marijuana in the workplace, it states employee, and this is what we're talking about. Remember, I said there's employee protections and employer protections, but I'm not sure they necessarily make this any easier on any of you, right? So the employee workplace safety shall not be diminished, and the employer workplace policy shall be interpreted broadly to protect employee safety. However, And you can still have a drug-free workplace policy, as long as it's applied in a non-discriminatory manner. And generally what that means is you can't say, hey, just because you're a marijuana card holder, medical marijuana card holder, we're going to do X, Y, and Z, right? It can't be applied like that. You can't discriminate against a card holder. But employer must have a good faith belief that an employee is under the influence and measure I cannot say this word, people, articulable symptoms. You can't discipline employees because of their use of a lawful substance during non-working hours or non-call hours. And again, this is where your relationship with DISA is pretty critical. And this is where you've got to see what a law like this does for you as an employer. An articulable symptom, despite my inability to pronounce it, is speech, physical dexterity, coordination, demeanor, like irrational behavior, negligence, or carelessness operating equipment or machinery, right? But now, how do you take this and apply it towards pre-employment? They're not an employee. This law talks about employees. How do you know if they use during non-working hours or on the job? The technology that's available right now and the levels of impairment and per se legal laws of impairment have not defined that properly, right? If you look at the window of detection with hair, it starts about a week out and it goes for up to 90 days. So a hair test then cannot be used in Illinois for someone who's 21 or older. It can for 21 or under because they're not allowed to have it at all, right? Oral fluid is almost instantly to about 18 to 24 hours. Urine is a few hours of use to up to about a week. So again, you've got to be working to define what are you doing, how are you testing, when are you testing, why are you testing? And you've got to look at your policies and how you're going to modify those in relation to these different laws. Now, again, every law is a little bit different. And so if you're an employer who does things across the U.S., you've got to be considering it by state. And again, DISA's policies are all states, all 50 states, all DOT modes. Now, the other thing I'll say is it's interesting to note that all of this is going along when we're seeing other numbers come out. And we're not going to go through those numbers, but you've got to be cognizant and aware of those as a safety person, as an HR manager, right? So what we don't go over here are things like AAA, and I don't have that in front of me, but AAA Foundation for Traffic Safety. They do great studies. And I know that so AAA, NHTSA, say that the impairing time frame for marijuana is about an hour to 4 hours after using the drug. What they know is that it alters like reaction times, impairs driver's judgment, all that kind of stuff. We all kind of know what that's like. But they did a survey and they know that 13% of Americans viewed driving within an hour after using marijuana as only slightly dangerous or not dangerous at all. So you've got to take that and say, well, then I guess they also assume that it's not going to affect their work within an hour, right? 70% of people in that study said that they believe the driver's unlikely to be caught by the police, so they're not really worried about it. Millennials are most likely to report driving within the hour of use. About 14% of Generation Z, about 14% of like millennials and 10% of Generation Z. So I don't know what your workforce looks like. So you've got to be thinking about that. So when you look at Nevada, this law goes into effect in January 1st, 2020. Employers cannot fail or refuse to hire prospective employees because of marijuana metabolites in their drug test. Now, they have limited protections for safety-sensitive industries. And again, I prompt all of you to be working with your legislation, to be talking to your lobbyists, to be talking to the different governing officials and say, hey, now the costs of this, these people who are going to come on our job site, who are going to be stoned, who are going to believe, because 70% of the people do, that they're not impaired. Well, now we're going to pick that up as an employer, right? So, in the safety-sensitive carve-outs in Nevada are firefighters, emergency medical technicians, any position that requires an employee to operate a motor vehicle, and of course, none of these preempt DOT or federal mandated testing, but any position that in an employer's opinion can adversely impact other safety, right? That's your loophole. How do you look back at your positions right now and say, I believe as an employer that this person could adversely impact other safety? And if you can, then you make them safety sensitive and this law doesn't apply. But again, you've got to be working with your internal legal team, with the compliance officers in your workplace, with DISA to really determine, can you, pass the litmus test for what safety sensitive is. New York City, starting May 9th, 2020. Now it passed a 30-day time period, so the mayor didn't sign it. He also, I believe right around that same week, decided he was going to run for president, and so maybe he was busy. But because it wasn't signed, it went into effect. And so in New York City, the 5 boroughs, you are prohibited effective May 9th for testing for THC as a condition of employment. Again, there's limited protections for safety sensitive. They're different than Nevada. So it's police, it's peace officers, it's some construction sites, obviously like law enforcement, supervision of children, medical patients. So it's different. You also could go, and apparently there will be, because they're still not, other employees or members of the public deemed by the Commissioner of Citywide Administrative Service or the chairperson, you can have exempt personnel there. And remember, the tough part about this is it's working in New York City. So it's not based on where they live, it's where they're working. And so there's challenges with implementing things like that. And that's what these legislatures aren't taking into effect, right? Legislators, they're not taking into effect the complexity of trying to manage this as an employer beyond all of the costs that you'll assume for accidents and injuries, beyond all of the costs that you'll assume when you see losses, productivity, or losses due to theft, absenteeism, higher turnover. So again, I really advocate that you're not only aware of this, but you're advocating on your behalf as an employer. And then there's other states, and I'm not going to go through these in detail, but look at the different states, look at the different laws, look if there are qualifying positions there, if it affects you as an employer. Oklahoma was a significant one. I know a lot of you do work in Oklahoma, and they've changed different things. And you got to remember, and I think we have this in an upcoming slide, there are different kinds of laws that apply in different states. We're going to talk a little bit about that. But if you look at this slide, you're going to see how significant. If you happen to be in a state where it's not colored in, then those states don't have pending marijuana legislation. All of the others do. And again, clear blue sky, right? So Indiana would, and again, this is pending. Indiana would legislate medical marijuana with an implementation date, allowing federal people who are getting federal funding to not discriminate for marijuana card holder status and test for marijuana. Kentucky has 2 different ones pertaining to medical marijuana. Massachusetts, to eliminate workplace drug testing for marijuana. Employers cannot test for marijuana as a condition of employment, includes certain positions where the law does not apply, such as excludes, like DOT positions. So they're very different. You've got to be active. You've got to say, hey, we are not for this. And it limits us too much. And we assume the costs of adding marijuana users into our workplace without the current tools and laws to limit it, right? So be mindful that creating a per se legal limit that aligned with impairment, and a per se legal limit simply means that it's a number for the law. So 0.08 in every state except Utah, where it's 0.06, is defined as the legal law for impairment for alcohol. We don't have that universally across states. We don't have the data because we haven't studied it because marijuana has been a Schedule I drug. So we don't exactly know what the right one is. The states that do have a legal limit were pulled not based on science, but they were really just pulled by the responsibility of some of these people making it legal, saying we have to have a legal limit. And so some of them have 5 nanograms, but there's really no scientific evidence to prove what that means. So really complicated times. There are other state law updates like Denver. It's not all marijuana, right? Denver and Oakland actually decriminalized magic mushrooms, made famous by the 60s sort of counterculture. You've got to know what you're going to do about that. So imagine having somebody in your workplace hallucinating or, having a bad trip, and it's now legalized. So you've got to deal with it in your policies. You've got to understand how you're going to do it. Tennessee's interesting because Tennessee has 2 different things. They have, all states have either, laws that are mandatory by industry, or they are voluntary. And the voluntary laws can give you workers' comp premium discounts, or they can help protect your workplace if you have a workers' comp claim or you're going to do unemployment payments to someone. Now, marijuana in their voluntary laws say that they'll only consider prescriptions that were issued within 6 months. So again, got to look at your policy. What do you consider a valid prescription when you're working with the medical review officer? And if you are following the Tennessee voluntary law, you've got to update that, right? And again, it's your obligation to let your MRO know that you're following it to get that discount. Other legal updates are listed here. I'm not going to go through them because I promise I try and not keep everybody for the full hour, but it's really important to look. Oklahoma updated drug testing cutoff levels. What's funny is we found that most people never actually followed them in the first place. So you got to look at what the levels are and make a determination as to whether or not you're going to change it or not in your states. Many didn't. And the funny thing about some of these is you've got to weigh your risk, right? Weigh the risk. And in the last section of this, we're going to talk quickly about audit, but weigh your risk because that's really important for you as an employer to determine, is it more important for you to modify your panel or to modify your rules or to, wait to see. And we have some safety sensitive employers who are saying, look, we're waiting to see. We're willing to be taken to court to challenge this because safety is so important to us, and ensuring safety in our workplace and matching the right candidates and being able to do pre-employment testing as a way to assess candidates that work with us best. And so they're saying we're going to continue on. But again, conscious decisions really need to mirror your comfort with risk versus, oh my gosh, I didn't know we had to update our policy. And so now we've got a challenge. So look at some of the required policy changes. We know that a good policy is really important. We also know that about 81% of policies are incomplete and 67% of employer policies don't address employee prescription drug use and abuse. Marijuana falls in this ugly gray line between prescription drugs, illegal drugs, and use, right? Prescription drugs, again, cause a different set of complications that you've got to address in your policy. Because much like marijuana, when you're talking about post-hire testing, you want to be saying, are my employees under the influence? Are they impaired while on the workplace? Impairment can happen from PCP, it can happen from heroin, it can happen from marijuana, but it can also happen from your 5 milligrams of oxycodone as directed being taken in a legal prescription. So you've got to look at your policies and you've got to say, are we adequately addressing it? This is not something the medical review officer can do for you. This is not something that a doctor is going to do for you. You have to say, hey, look, if you are in a safety sensitive role in our company, you as an employee have an obligation to make your prescribing physician aware that you are, and to ensure that you can do that. So those are drug disclosure type policies, and you've got to make sure that if that pertains to your workplace, that you've considered a drug disclosure policy. Because if I'm taking that 5 milligrams of oxycodone as prescribed, the medical review officer sees my prescription, they will say this person is okay. Person's okay to hire. Person's okay to perform that job. If it's a safety sensitive job, then you as an employer haven't done your job in saying, all right, we need a second level here. The second level is, if you're in a safety sensitive role within our organization, you need to work with your prescribing physician to make sure that you're fit to perform the job functions that we're hiring you for. And if not, then we work with you either under ADA, under FMLA, and you either find a different position for that person if you're covered under FMLA, or if you're covered under ADA, or you simply can't perform those functions. And so you've got to be working at that. So defining safety sensitive positions is critical, and knowing what you're permitted to do within job related and business necessity, the lines of HIPAA, all important, all things that you've got to address in your policy. Your policy is to be clearly written. You don't have to spell out every drug you're going to test for. You don't have to spell out things that you're going to, we've got a little funny S in this slide, I noticed. But you don't have to do that, but you do have to make sure that you've addressed the positions. If you're going to have a medication disclosure policy, you need to address that. You got to talk about how you're going to handle prescription drug restrictions. You've got to focus on the consequences of the violations, and what the employee's responsibility is, because the employee has a responsibility in many of these things as well. And then, simply stating that the illegal use of prescription drugs are prohibited. That's where that Tennessee law came into play, right? Because they were saying, hey, look, if Nina French has her prescription for oxycodone that is 12 years old from when she had her 12-year-old twins, it is not okay to be using it now. The DOT does not set a date. So you need to, as an employer, because you may get a safety concern, right, from the MRO. They're going to say, hey, this is a safety sensitive position, or we are a DOT position. Somebody gave us a script and it was 12 years old. And so that's going to trigger for us, among a bunch of other things, right, a safety warning. And then it is not your DOT policy. The DOT does not say anything other than to say you have to remove that person from a safety sensitive position, but they do not give you employment actions that you've got to take. And so your non-DOT policy really has to address that. So you've got to implement that drug-free workplace policy. You need to make sure it's up to date, and really you need to train on it. And so that's the next step. Make sure if you're DOT, you got to get your policy updated. Make sure it's up to date. Make sure it conforms. Make sure then the things that sort of line up, like we just said. Well, so now if I get a safety warning from the MRO, how am I going to address Nina taking her 12-year-old oxycodone script? We think she's got a medical issue. We think this could be an issue. Well, now how is that non-DOT policy going to kick in? So you've got to look at all of the different policies. If you're in those not mandated states, then they've got to comply with the mandated laws in the state. If you're trying to comply with the industry-specific laws or the voluntary laws or the marijuana laws, you've got to have that by state, right? And not just state. San Francisco and Boulder, Colorado have their own rules as well. So you got to look at all of those different things and make them specific to your organization. There's no one size fits all. There's no such thing as a sample policy that's really going to cover you. And then you want to go into employee education. Now DISA has a wide variety of employee education. Again, I've been in this industry for well over half of my life. I like to say well, so it makes me sound younger. Employee education is really key. Training is really key. It's part of the communication effort. The DOT has specific training requirements, and you need to follow them, and they vary by the different agencies. DISA actually has a great little tool that they can provide you that shows what the different agencies require. Some require an hour of alcohol training and an hour reasonable suspicion signs and symptom training for alcohol, reasonable suspicion signs and symptom training for drugs, right? Some say you have to do it recurring, but then tell you what that means. Others don't. But you've got to understand what your requirements are. Then there are state training requirements. Different states require employee training and different states require supervisor training. And you want to be able to say that you've done the training, not only because it does a couple different things, right? If all of your employees are trained and if all of your supervisors are trained, whether or not it's required, it does two things for you as an employer. The one is it gives you lots of different sets of eyes. And oftentimes, someone who's impaired, under the influence, or operating unsafely, it's going to be brought to your attention in HR or safety by another employee. So training them on how to effectively do that notification to you, how to approach or not approach, by the way, the other employee is really important. It gives you all those extra set of eyes. As well, it gives you an added layer of protection, right? We're involved at CCG in helping with lawsuits right now that we're seeing where, you cannot prove that training and drug testing will prevent necessarily every accident in your workplace. But what you can do is you can prove by implementing those types of training and safety programs that you as an employer, right, random testing, reasonable suspicion testing, post-accident testing, pre-employment screening, you as an employer, through those training mechanisms, have done your best, done diligence. You have a program of safety. You're not negligent. And those are important, and that's why training is important. So whether or not the state or the DOT requires it, it's really a best practice. DISA has expanded. They've always had it. Now, they've partnered and got new training compliance management system, and it's a series of videos. There's downstream benefits, right? So your employees and your supervisors can take it online. It's sort of self-managed training. They can stop it and start it. They have quizzes. It's got some interaction in between because let's be honest, right? 2 hours of training on, reasonable suspicion signs and symptoms for alcohol, reasonable suspicion signs and symptoms for drugs as required by the DOT for supervisors can get a little bit mind-numbing. So the trainings are designed to keep people, interacting with it. They're also already approved for SHRM credits, for CCDAP credits, for HRCI credits. And so that's an added benefit for your employees and for your supervisors because they can get that. And what's important for you is you not only meet or exceed the requirements of the Department of Transportation or those different states, you've got written proof of your program and that it met or exceeded those standards that you can bring out in the event of an audit or a review. So, everyone benefits from the training. Each of the courses gives the recognition of workplace alcohol symptoms. They also all come with some forms, right? So if you don't have forms that have been updated that you can document an accident, document signs and symptoms. Those are key as well, and these come with them, the supervisor training courses. And then there's also bigger forms packets available for all of the different DOT agencies. But there's a whole different list, and it gives an overview of the different employee trainings, the different DOT trainings, the different DOT agencies, and it meets or exceeds all of those different requirements for you. And it isn't generic, right? This is not something that a training institute with 6,000 other courses puts out and makes available to you. It's created and maintained and updated so that it is done by industry experts with scenarios that are real life, right? Just like I said in the beginning of this, I don't talk to you by reading to you the legal briefing. It really usually doesn't resonate. The trainings on DISA's website, or you can contact them and do them in person if you're looking for a big audience. They've got training at DISA, so you want to look at all the different options. But they're real life scenarios that people can really grasp and that give them hopefully easily translatable skills that they can sort of go back to their workplace and start to use right away. And so I think it's really important that these are not generic trainings, and that you can get access to something that's updated all the time. You know it's right. You know it's in compliance with any of the regs in the state regs. So, and you can get those certificates. People like certificates. I actually am, in my office with a bulletin board on my wall that has certificates of all sorts of different silly things, good, bad, or indifferent. People like the certificates, but they can also run for you if you're looking at a big organization who's doing a lot of training. You can look at the different trainings that your team has done, and they can run your report if you're in the event of an audit. And that's really what we're going to cover last, right? What do auditors look for? If you're a DOT covered employer, then you will or may get an audit. One of the things that auditors look for are training records, right? They want to look at your DQ files. They want to look at your files that show that you looked back and received a person's prior drug and alcohol testing records. They want to make sure that your DERs are properly trained to handle employee test results and records. Super important part. Easy to manage, and yet you'd be surprised how many people cannot prove that they've trained every single employee and every single supervisor. And again, keep in mind, it's not just protection for the audit, it's really being able to, in the event of a challenge to your safety procedures, it's a way that you as an employer can come back in and say, yeah, we've given all of this training. We do have our eye on safety, not only as a requirement, but we've kind of gone above and beyond. And we've made this available to our entire population, and we have a mechanism by way of these online systems to go in and to say, people have been trained, our policy is updated, we are aware of what our requirements are. And then if you actually get an audit, the team at DISA, you notify them, and they can actually come out and do what's called a mock audit, right? So a mock audit is really just helping you prepare for that auditor coming in the door, or again, it is a preemptive mock audit to say, all right, we want to annually or periodically, or just to get a comfort level that you feel good about, have the team at DISA come in, look at how you're doing things, and give you the same feedback that you would get from a DOT auditor, so that in the event they do come in, you're assured that you're doing things correctly and properly. And so went over my promised time, but with that, Kalinda, I will turn this over to you.
So, Nina, wow, that was a wonderful presentation, very clear and concise and thought-provoking. And as a result, there may be some instances where individuals have questions. And so for our audience, what we would like to encourage you to do is to ask your questions by submitting those questions, by posting them in the chat, and those questions will receive responses in the immediate future. You said so many good things here, Nina, particularly around the online training. I think that it is such a privilege when such a clear resource is available. And the experts that have worked on the compliance training, they really put a lot of time into it with the audience in mind. So we really want to encourage our audience to take advantage of DISA's compliance program. And then the policy review and updates. I think the references to the legislative updates and just the climate changes really does inspire a need for, employers to look at their policies. It's interesting because in many instances, it seems that the employees know the loopholes a little bit better sometimes than HR. And they know the changes that are in their favor. They know how to benefit from that, and they also know when those policies don't capture the information that's necessary, particularly when a state requires it to do so. And then your reference to the mock audit. There is no preparation like being prepared. And so I think the audit support is also very key. Online training, policy review, and creation, and then mock audit and audit support. So what I want to do here on this slide is specifically talk about DISA and how DISA's clients and non-clients are able to access this service. So whether it's training or whether it's policy review or creation, or it is audit support, a non-client of DISA will have to contact DISA's sales department to establish an account in order to access any of these services. If you are a DISA client, I'm going to go individually through what needs to happen very quickly. So for training, a prerequisite for a DISA client is you must be registered for DISA's training services. So you register for training services by contacting DISA's account setup department at clientupdate@disa.com to establish the training access. So again, that's clientupdate@disa.com. If you've had your training, clients can access compliance training via DISA Works 2.0 or DISA Works Classic under the Training tab. For individuals that are interested in policy review, for current DISA clients, you just need to submit a request detailing the need to DISA's training department, and it's policyinquiry@disa.com. If you have audit review support that you're seeking, it's the same step. Submit a request detailing the need to DISA's training department. What I'd like to say in terms of policy review, policy writing, and audit review, it is most helpful when the employer knows exactly what they want and the specifics of what they're needing, because that makes it very much easier for DISA to give a response in terms of the associated costs with that service. Nina, again, I can't thank you enough for spending your time with us today and providing an overview. I'm sure that all of us walk away much more informed than when we started this call or webinar at the top of the hour. Can't thank you enough. Do you have any parting words for us today that clients and other audience members can take into consideration as they go back to their work and think about their next steps?
No, just that I guess the closing comment is thank you for having me, and I hope that they take advantage of what you've got available for them.
Okay. Thank you, everyone. Don't forget your questions. We'll respond to you in the immediate future, and we hope that everyone has a great day. Thank you for joining the webinar.
Thanks. Bye-bye.
Bye-bye.